Hey students, welcome to Supreme Court Cases for Honors Gov. We're going to be discussing some key Supreme Court cases today. So the freedom of speech cases we're going to be looking at obviously help to establish some main ideas about how indeed freedom of speech is going to operate in society. Free speech is obviously not an absolute freedom. All of our freedoms, in other words, are going to be weighed against other competing freedoms. So just keep in mind, though, that the Supreme Court over time is going to determine to what extent is free speech going to be protected. And we're going to look at some court cases that are going to give us insight into that. So the first court case we're looking at here is Gitlow v. New York, which involved a socialist in New York who had printed leaflets discussing his position against the war effort at that time. And he was basically advocating for people to also take up this cause. And he was ultimately convicted under an anarchy law in New York for undermining the war effort. He challenges this law, suggesting that the law is actually a violation of his freedom of speech, that it indeed, got in the way of him being able to express his, feelings or ideas freely. In this case, political speech, in particular, we're going to find out, deserves an extra level of protection because of its role in society and how important it is to have an exchange of ideas. But ultimately, the court's going to rule against him. Nevertheless, the court recognized that First Amendment freedom or protections extended to states as well. And this was really important because there was a prior case in Barron v. Baltimore where the court said that the freedoms, or I should say the protections afforded to you in the Constitution, only applied to limiting the federal government, or only were applicable to the federal government. So in other words, if a state or a local government violated one of your protections under the Constitution, too bad, so sad, up until this court case in Gitlow v. New York. And that was in large part due to the passage of the 14th Amendment, which we've already discussed with you why that allowed the federal courts to apply some of these freedoms and protections to you on the state level. So on that topic, selective incorporation is a very important concept to understand. Ultimately, what is it? It's the process by which the federal courts are extending or applying the protections of the Bill of Rights to the state and local governments in the U.S. You'll notice that we put much of the Bill of Rights because not all the Bill of Rights were applying to you immediately after one decision. The courts are reactionary. They have to wait till people bring an issue to them before they can determine if this is constitutional or not. So we're going to find out that the courts will take up the various rights and freedoms that are afforded to you in the Bill of Rights on a case-by-case basis. So since the case of Gitlow v. New York, the Supreme Court has selectively incorporated most of the provisions of the first 8 amendments in the Bill of Rights. So in other words, they've done it on a case-by-case basis. This is why we call it selective incorporation, because they're looking at each individual freedom or protection in a particular case and determining whether or not that freedom or protection is in fact fundamental. Because if it's not fundamental, it then doesn't need to be applicable to you on the state level. But again, I want to stress to you that this particular principle is really important in allowing the federal governments, specifically the federal courts, to review state laws to determine if they were violating freedoms afforded to you in the Constitution. And so the remaining cases that we're going to look at all stem from this principle of selective incorporation.
Okay, so now we're looking at the legal standard, like why or how are the courts justified in telling the states that they must protect these fundamental liberties? So the answer is found in the 14th Amendment Due Process Clause. So you can see here the 14th Amendment Due Process Clause says, nor shall any state deprive any person of life, liberty, or property without the due process of law. So What the Supreme Court was saying in Gitlow versus New York and in some of the other cases we're going to look at is that the states also cannot deny you your basic rights, your fundamental liberties, such as freedom of speech, freedom of press, right to a lawyer, right not to be searched illegally, right not to be subjected to cruel and unusual punishment. Again, they haven't incorporated all of the Bill of Rights, so it wasn't total incorporation. It's selective. It's done on a piece-by-piece or case-by-case basis. But the 14th Amendment is basically saying, so no state can take away, for instance, your freedom of speech. No state can take away your freedom of religion, etc. So if your rights are violated by your state or local government, you can take it up with the federal court system. And so this shows you just the process of incorporation and in different rights and how they've been selectively applied. So you see parts of the First Amendment and the Sixth Amendment and the Fourth Amendment, but you also notice there are some missing. The ones that are notable, you see the Third Amendment has not been incorporated. In other words, states have not been told they can't, force local citizens to keep law enforcement or military people in their home. Of course, that wouldn't really apply much anyway to the states, but also the Seventh Amendment that says you have the right to trial by jury in a civil case or a suit of common law has not yet been incorporated. That doesn't mean it won't be at some point in the future, right? So sometimes someone might be in a civil trial at the state level and they may challenge the fact that they were denied the right to a trial by jury, and they may take it up with the federal court system, and that might in fact someday be incorporated, but so far it hasn't been. You notice the Second Amendment isn't on here, but that has since been incorporated.
So these two court cases demonstrate exactly how the selective incorporation principle works. For example, the Fourth Amendment, when it was incorporated, was in the Mapp v. Ohio court case, which essentially ruled that whenever officers or federal officials, whomever, obtain evidence illegally, that evidence cannot be used against you in a court of law. And because of that, you'll notice in both of these examples, you'll see in the naming of the case, in the one case in Mapp v. Ohio, the state of Ohio specifically mentioned, in McDonald v. Chicago, obviously a city. And if you remember, we said that the selective incorporation principle allows the federal courts to review state and local laws, right, including municipal laws, to determine their constitutionality and to extend the protections they afford to you on the state level. So in Mapp v. Ohio, we saw that the Fourth Amendment protections against unreasonable search and seizures apply to you on the state level as well. And in the case of McDonald v. Chicago, we see the right to bear arms. The conservatives on the court in particular recognized an individual right to bear arms and said that essentially state and local governments have to also recognize and protect this right, and they cannot unduly burden someone's right to obtain a firearm, as was the case in the McDonald v. Chicago case.
Okay, so a little quote here from Chris Tucker from Rush Hour.
Do you understand the words that are coming out of my mouth?
Okay, so we're just trying to say, do you guys understand this yet? So if you don't, let's look at it one more way. So think of it like a math problem. And in this case, you have the Second Amendment right to bear arms, which is in the U.S. Constitution, plus the 14th Amendment due process clause, which is in the U.S. Constitution, but says no state can take away your rights. So if you add the Second Amendment with the 14th Amendment due process clause, what does that equal? The government of Chicago, which is part of the state of Illinois, must also protect people's Second Amendment right to bear arms. So again, it's taking what used to be only a national right, a right that had to be protected against the national government, and it's saying not only does the national government still have to protect this right, but the state governments also must protect this fundamental right. So this case is interesting because it actually sort of reverses some of the earlier cases, one that we didn't look at called Schenck versus the United States, but also the Gitlow case in a sense is sort of redefined. So remember, well, we haven't told you probably, but the courts can overturn themselves. They can set a precedent, they can make a ruling that sets a new legal standard or legal example, but the future courts can change their mind. The only court that can overturn the Supreme Court is, in fact, the Supreme Court. And so in this case, the court kind of reverses the courts of 40 or 50 years earlier. So in this particular case, the background was a guy named Brandenburg, who was a leader in the Ku Klux Klan, held a rally and gave a speech, and he invited reporters to come cover it. And one reporter came and they filmed it, I believe. And so in his speech, of course, he used a lot of racially charged language, and some of the members were armed, and so it was kind of seen as possibly threatening. He was charged for this speech under an Ohio law that prohibited crime, sabotage, violence, or unlawful methods of terrorism in order to accomplish political or industrial reform. So he was arrested under this law, and he claimed that his rights were violated under the First Amendment. So did Brandenburg's conviction violate the First Amendment? Is the court had to answer that question. Should he have been convicted simply for what he said and the fact that some of the things he said seemed to be threatening? And so the court ruled that yes, his First Amendment rights were violated, that this law was overly broad, and that they established this new test for determining when speech can be limited by the government, again, especially when it comes to political speech. And the new standard is sort of, is it going to lead to imminent lawless action? Is it likely to produce such action? So in other words, your speech has to be not only derogatory, or in a sense, it can be hateful, but is it about to lead to violence or lawless action? Is it so over the top that it's about to cause some riot or some violent act to be committed? At that point, if that standard is reached, that person their speech could be shut down, and if they refuse to stop speaking or inciting violence, then they could be arrested and charged. So basically, if your speech is really about to lead to imminent lawless action or violent action, then it can be restricted or prohibited.
In this next court case, there are a couple questions to consider. In this particular court case, we have students in Des Moines who were planning to wear black armbands as a show of support for a truce in Vietnam during the Vietnam War, ultimately looking for peace to be struck between the various parties. But the principal and administrators found out about this plan, and they subsequently issued a rule that anybody wearing an armband would be, if you will, they would be suspended if they wore it to school. And in this case, obviously the students were very committed to this cause. They wore it anyway, and they were subsequently suspended, and their parents sued that this was a violation of the students' right of expression. So a couple questions to consider here, right? First is, there's not a verbal expression being challenged here. In other words, the students weren't verbally saying anything. They were simply wearing an armband. And so is wearing something a form of speech per se? And is it also going to enjoy First Amendment protection, right? And the second thing that we have to consider here is these are students in a school. Do they enjoy the same level of First Amendment protection, say, as an adult does in the public domain? And the court essentially, in this case, ruled in favor of the students, saying, one, yes, that wearing black armbands is a form of expression and will receive protection by the First Amendment. In particular, these armbands were meant to communicate a political message or belief, and so this is certainly something that would have been anticipated and embraced by the First Amendment freedom protections. And secondly, students do not shed all of their constitutional rights once they enter the schoolhouse gates. In other words, just because they are in the custody of the government at that point in a specific environment and under our supervision, they don't somehow now lose all of their ability to say what it is that's on their mind or think. However, I do want to caution you that, there is a rule here that the court lays out as to when a certain particular action or behavior substantially disrupts the curriculum or the ability of the school to do or perform its main duty, which is to indeed educate the students. So in other words, the court had to also look at whether or not the fact that these students were wearing black armbands, was that going to be substantially disruptive to the classroom environment or the school day? And they found that it wouldn't be. But if they had, or if what you're planning to do would be substantially disruptive to our ability to have our curriculum or teach you our curriculum, then the court would have sided more so with the school or the administrators in being able to curtail that kind of behavior, because you're undermining the key, one of the key purposes of school, which is to make sure that students are being educated accordingly.
All right, this next case, again, is, you guys should already be familiar with this as well as Tinker if you watched the video that we assigned. But so this was the case of Texas versus Johnson. So Gregory Lee Johnson, or he went by apparently Joey Johnson, burned a flag outside of the Republican National Convention in 1984. He was part of a larger protest against the policies of Ronald Reagan. And I think in particular, they were focused on things like nuclear war and proliferation. But anyway, he burned a flag and was arrested for violating a Texas statute that made it illegal to desecrate the flag. In other words, to sort of show disrespect to the flag. And of course, the question was this type of action protected under the First Amendment? In a very narrow decision, the court ruled that yes, in fact, the right to burning the flag, in fact, is protected under the First Amendment. This would be an example similar to Tinker, where we would call this symbolic speech. So symbolic speech, speaking through symbols or even actions that are nonverbal. So burning a flag, wearing an armband would be examples that would fall under symbolic speech. What the court has essentially said over time is that freedom of speech is not literally limited to what you say. Freedom of speech may also protect other forms of expression. So in this case, although it was a controversial ruling, the court said burning the flag is a form of political speech that should be protected under the Constitution.
In Miller versus California, we take up a new form of expression, and this is whether or not there are forms of expression that are obscene or so obscene that they won't warrant, if you will, protection. In this case, we're looking at pornography. Miller had been conducting a mass mailing campaign to advertise the sale of adult material. And there were people who complained about this, and he was ultimately convicted of violating California statute prohibiting the distribution of obscene material. Miller is arguing that this is a violation of his First Amendment free speech rights, but in particular the freedom of expression. This form of expression, in other words, maybe some people see pornography as an art form of sorts, or it is certainly a version of expression, expressing oneself, but whether or not it deserves First Amendment protection was another question altogether. Now, mind you, the court had taken up this issue before in a court case called Roth v. U.S., where they decided that, in fact, that pornography was not going to receive the same level of protection, say, as other forms of expression. In other words, there were adult material that would indeed be considered obscene and would not receive First Amendment protection. But the standard that came out beforehand in Roth was a much more liberal standard that nationalized whether or not something was considered obscene, and it used modern community standards. So even these smaller communities that may have had different sensibilities, they were having to apply a modern standard to determine whether or not the material would be protected, or that was the law at that point. Well, a slightly more conservative court took up this case in Miller, and actually in a 5-4 decision, and you can see it was a very close decision, held that obscene material didn't enjoy First Amendment protections, And the way you would determine if something was obscene is that if it had no social value to society, it could add no social value to society, and the community standards are able to apply here. In other words, what may be obscene in one community may not be in another, and that was okay in terms of whether or not something could be prohibited. So this standard was seen as slightly more conservative and limiting maybe, but as you know, modern times have come around with internet and whatnot, those things have, this standard sort of has been watered down or diluted to some extent in terms of what you can have access to. Look, as far as how do they determine this, obviously the judges, they set out a standard, but whether or not something qualifies as obscene or not in the area of adult material is on a case-by-case basis. And ultimately the courts are in the position of deciding whether or not something runs afoul of this or not.
Okay, this case I wouldn't say is considered as big of a case compared to some of the others, but it's kind of interesting. Brings up issues relating to speech, again, controversial forms of speech. In this case, you had a soldier who had died, Matthew Snyder, I believe in Afghanistan, so they were holding his funeral. Well, there's this group called the Westboro Baptist Church, and they have very, I guess, out of the mainstream viewpoints, or very, I guess, viewpoints that most people would find, just to be, I guess, a bit bizarre, that they think that because that God actually causes the death of our soldiers and kills Americans as a punishment for how America is too liberal on certain issues, particularly relating to things like abortion and gay rights. And so, basically, as the father and the family of Matthew Snyder were pulling into his funeral ceremony, there were these protesters from this church, and I believe it was out of Kansas, that they were sitting there with, as they usually do, with signs at military funerals, and they say things like "Thank God for dead soldiers" and other things that are even worse. And so obviously the father was very upset by this, or the family was very upset by this, so they sued the church and the leader of the church for emotional distress and basically seeking compensation from them or some type of penalty for their offensive protests. And the question was, does the First Amendment protect these protesters from being sued? Can they be sued for simply expressing, a viewpoint that was very controversial and very upsetting, as you might understand, to this family? And the court said no, that that yes, the First Amendment does protect these rights, that no, he can't sue them. And the First Amendment supersedes any type of emotional distress or damage that might have been caused to the family. And again, it's important to remember that the First Amendment protects a lot of people who say things that we might find highly offensive or disturbing, but the law tends to side with those viewpoints in order to have as much expansive protection of First Amendment expression, especially when it comes to political expression. And although there are some limits on that this shows just how broad those protections are.
It reminds me, before I move on to the next case, Candide, a famous philosopher, said, "I may vehemently disagree with what you have to say, but I will die, or I'll fight to my death for your right to say it." So what it means to really be in a free society means that you're going to be exposed to speech or ideas that you really disagree with. And yet, in order to have a free exchange of ideas and to really have a robust and intellectual debate about them, you have to be open to being exposed to them. Now, you don't ultimately have to embrace ideas. I think every single member of the Supreme Court found the utterances by the Westboro Baptist Church to be abhorrent and repugnant and repulsive. But they recognize that they still enjoy protections, because if free speech means anything, it has to be that it applies is precisely when that speech is unpopular. Because if it only applied when it was popular, it really truly wouldn't be a free society. All right, so that brings me to the West Virginia State Board of Education versus Barnett case. And so again, that lead-in, you'll understand why I raised those points. In this case, we have Jehovah's Witnesses, students who refuse to participate in the Pledge of Allegiance to the American flag on religious grounds. And if you're wondering why or what religious grounds they were thinking of when refusing to pledge the flag, it's because Jehovah's Witnesses believe that the only thing they pledge their allegiance to is God and God alone. And so that having to pledge allegiance to a flag is, in essence, forcing them to divide their loyalties, and that is against their belief system. And ultimately, the question before the court was, did the compulsory flag salute for public school children violate the First Amendment? Freedom of religion, right, in this case, because it's Jehovah's Witnesses bringing this case up for religious reasons, but it was also a free speech or a free expression case too. Ultimately, the court agreed, yeah, they were expelled. In fact, these students were for refusing to pledge allegiance to the flag. But the court sided with the students and their parents and saying that, forcing people to say the pledge is a violation of their freedom of speech and religious beliefs. And I thought it was really important to point out a particular utterance by one of the justices who said that, if there's any, you have to look at the time period, look at 1943. If you're aware of what's going on in world history at this point in time, we're wrapping up things, but we're also in the midst of things, I should say, with respect to World War II. It doesn't wrap up till a little later on. But in essence, we are fighting in the world, right? The United States, along with the other allies, against the Axis powers. We're fighting against countries that are authoritarian, that are forcing their citizens to think all the same thing, that are indoctrinating them and telling them they must do X and they must do Y, they must do Z. And this was truly dangerous to see the kind of atrocities that these governments were basically committing against other peoples, and were successfully convincing their own citizenry that it was okay to do these things against other people. It was truly a horrible, horrible moment. And so there was a danger the court recognized is, in terms of forcing people to do something as a form of pledging allegiance to your country, that compulsory nationalistic action would make us no different than, if you will, from other authoritarian or fascist nations. And so it was really important for the court to drive home that point when talking about this case, because there was a broader issue. I mean, there were other things happening in the world that certainly spoke to this issue of whether or not we're going to force compulsory actions with respect to showing national allegiance. And this debate still rages on today. It's particularly applicable, we still have conversations about, people kneeling and so on during the Pledge of Allegiance. Now, mind you, all of those things are perfectly constitutional, especially considering the ruling here in West Virginia versus Barnett, which is still good case law. And so it's important to know your rights. Now, again, that doesn't mean you shouldn't or you should. It's just important to know your rights, that you know that you have the option to whether or not to pledge allegiance, and that it's something you should do voluntarily, not because you're being forced to do so.
And just one last thing is this case shows just again how the court can overturn itself. In fact, this case, the court had just 3 years earlier ruled the exact opposite in a case with almost identical facts. You had students who had been expelled for refusing to say the pledge. It was Jehovah's Witnesses. And the court in that case had ruled that the school was okay to expel them. They did have the right to sort of compel students to show patriotism. The court reverses itself just 3 years later. Another case with First Amendment. In this case, we're dealing with the Establishment Clause and issues of both freedom of religion versus sort of freedom from religion, or the protection against government endorsement of religion. So in New York, as was the case in many states, or probably say almost every state at the time, was that they would have prayer in public school. They would start out the day with a prayer that had been written by the New York Board of Regents, which was in charge of the school. So they would, students would start out the day reciting a prayer. Now, it was voluntary. Students didn't have to participate, but the question still was raised, and some parents sued, saying that the school should not have a daily prayer, that this was essentially promoting a belief in God or a belief in religion that should not be part of the school day. And the court was asked, does a school-sponsored, school-written prayer that is recited by students, even if voluntary, violate the Establishment Clause of the First Amendment, the part that says, Congress shall make no law respecting an establishment of religion? And the court ruled that yes, even though it was voluntary, it's still unconstitutional because the government created the prayer and sort of they were endorsing the prayer by making it part of the school day, and students felt maybe pressure, even though they weren't forced, they would still feel some pressure to participate. And this simply saying that in this case, government should be out of the business of promoting religion, that essentially church and state, the church and the government, should remain separate as much as possible. So this was, even though some might claim that the students are just expressing their freedom of religion, in this case, they said, well, if you want to pray, you can still pray, but it would be on your own, not led by the school or endorsed by the school, which is part of the government.
In this case, New York Times versus US, we're focusing now on the freedom of press. But what you're going to see is that the court is going to treat the freedom of press as a protection tantamount or equal to the freedom of speech. But in this particular case, we have the Pentagon Papers case. Essentially, these were papers that had detailed how it is that the United States got into the Vietnam War, which is a rather controversial war at this time. And the Nixon administration was trying to find a way to wind it down, even though they were actually fully behind it. Indeed, LBJ, the president prior to Nixon, was the one who started this war, but Nixon wanted to see it to its end and continue it. But because of public pressure, ultimately had to find a way out. But in the process, a person who was working at the Pentagon had come across these papers and had released these papers to the New York Times and the Washington Post, and thought it was important for the public to know that the reasons behind how we got into the Vietnam War were actually not on the up and up, or not above board or above table, that there were some shenanigans and lies and misrepresentations for in terms of what led up to our involvement in the Vietnam War, and that the people should know that our government was not entirely honest with us when it decided to get into the Vietnam War. So in this case, the Nixon administration was desperately trying to prevent the publication of these articles and these papers, because he knew that they would be very damaging politically, also for the government. So that he argued, his administration did, that prior restraint was necessary. And if you're unclear as to what prior restraint means, basically censor or preventing the publication of something before it's even published. And the court said no. Now, what did the Nixon administration argue? Well, that this was necessary to protect national security, that if these papers were published, it would endanger our troops and put national security in jeopardy. And the court said, no, we're not buying that argument unless you can prove to us that there's going to be some immediate danger posed to either diplomats or our soldiers. In other words, you couldn't, for example, this court would protect prevent papers from trying to publish, troop movements. But that's not what was happening here. Essentially, what was happening is that, we had largely already at this time started to withdraw from Vietnam and were wrapping things up. So the court, rightfully recognized that there really was no great risk posed by the publication of these papers other than the political one. And that was not justification to ban their publication. In fact, the press exists to expose and to make clear to the people what the government is doing, good and bad, so that the people can make an informed decision. That's the only way this democracy, well, this republic can function. And it's a democratic republic at that, but it is a republic. But you have to have an informed citizenry, and the press plays a critical role in that aspect, an indispensable role. So the ruling here clearly was that the government had to reach a high bar. It had to prove that there was an immediate imperiling of the safety of American forces in order to justify prior restraint, and that bar had not been met in this particular case. So the takeaway is that the freedom of press is highly protected, just on almost on the same, well, at the same level as freedom of speech.
Okay, we're going to start or continue on with the Second Amendment, and there's only one case we're looking at for the second. And that case is McDonald versus Chicago. But for many years, the Supreme Court sort of avoided the Second Amendment, or Second Amendment cases did not really come before the Supreme Court in any significant way for the most part. And that changed in 2008 in another case, DC versus Heller. We're going to focus on McDonald versus Chicago since this was the case that incorporated the Second Amendment. So Otis McDonald and other Chicago residents sued the city of Chicago for a handgun ban that had been put in place. And so their argument was that Chicago had put a law in place that made it virtually impossible for citizens to acquire a handgun. McDonald wanted the gun to, he said, to protect himself from, potential criminals or break-ins or whatever. And so he said it was for self-defense and that he should have the right to a gun. And the question is, does the Second Amendment apply to the states, and is it an individual right of all citizens across the United States? And the court said yes. They used, again, the due process clause of the 14th Amendment to say that the Second Amendment right to bear arms is in fact an individual right, which they had already decided in the Heller case, but this applies it to all the states as well. So not only can the federal government not deny you the right to bear arms, but no state or city government can deny you the right to bear arms. In the Heller case, the court did leave open the possibility that states can regulate, and federal and state governments can regulate gun ownership. So this is not saying that gun ownership is an absolute right, but it is saying that basically you can't be completely stripped of your gun rights without a cause, like if you were a felon, for example. And so this, again, incorporates the Second Amendment. This and the Heller case were major victories for people who support, gun rights and Second Amendment, and groups like the National Rifle Association.
So our Fourth Amendment case is an interesting one. It's one of my favorites. Basically, to remind you here, I want to just say that the Fourth Amendment, of course, protects you from unreasonable search and seizure unless a warrant can be provided, which specifies the place and persons to be searched and or seized, possibly under oath and affirmation. So there are various steps, of course, that the Founding Fathers wanted to ensure the government had to take prior to searching and seizing any property or persons. And this was this was a sensitive issue for them because they were subject to a lot of unreasonable searches and seizures. The colonists were during the time of the British Empire, who oftentimes were searching homes and people for goods that were imported and had not had their taxes paid on those goods. Regardless, the point of the matter was that this particular provision or amendment was something that the Founding Fathers considered very important in safeguarding us against abuses by the state. And in Map v. Ohio, we have a situation where Dole Re Map was suspected of housing a fugitive. And in addition to that, there was the belief that in her house were bomb-making and gambling material, gambling equipment and bomb-making material. So the police arrive at her house and they don't have a warrant, incidentally, initially. And she actually asks them to provide one prior to entering her home, which she has every right to. The police, didn't have one, so they had, one or two of them on the porch, and the others went off, and they, in fact, got more police officers and ultimately had scribbled some writing on a sheet of paper. Mind you, it was not a warrant. It was not signed by a judge or anything like that, but they were going to pass it off as if it was. And they present very briefly the paper, and then put it back down and sort of force their way into her house. And they Dolry sort of grabs the paper and tries to see if it's in fact a warrant. And anyway, there's a bit of a tussle, not very much of one, but ultimately the officers don't find any gambling equipment. They don't find any bomb making material. But what they do find are some, magazines with, nude characters on them near her bed. And they ultimately seize those materials and then subsequently try to prosecute her for possession of obscene materials, even though that had nothing to do with the original purpose for their presence there. And the question before the court was ultimately, was this a violation of Dolry Mapp's Fourth Amendment protections? And in this case, do they apply, to her on the state level? Remember, the question in many of these cases is, again, does the protection offered to you in the Constitution apply to you on the state level as well? And what the courts are trying to determine is if that protection or if that liberty or right or freedom is fundamental. And ultimately the court decides yes, that the right to be free from unreasonable search and seizure is indeed fundamental. It does apply to the states. In particular, here they develop a rule called the exclusionary rule, because if you will, they were trying to, the question was posed, well, they did find illegal material. Can Dolry still be prosecuted for that, even though that was not the original purpose for entering into her home, and despite the fact that the officers failed to obtain a warrant? So can incriminating evidence that is otherwise obtained illegally because the officers lacked a warrant, can that still be used against a defendant in the court of law? And the court said no, that this would be a violation of the Due Process Clause of the 14th Amendment. So that was the resolution in this case, was that the exclusionary rule, basically also called the fruit of the poisonous tree. The idea being is that if you obtain this evidence illegally, you can't use that as a reason to prosecute someone, even in fact, if possession of that material was illegal, because there would be no real protection against police abuses. If they knew they could still try to find something on you, well, then the police could still abuse your rights to be free from unreasonable search and seizure.
All right, so this other case dealing with the Fourth Amendment is, how does it apply to students at school, or does it apply to students in school? So in New Jersey, a student, they used her initials since she was a minor, TLO, was supposedly caught smoking cigarettes in the bathroom by a teacher. She was taken to the vice principal's office, and he asked to search her purse after she had denied smoking, and she did not consent to the search, but he searched it nonetheless and found cigarettes, a small amount of marijuana, a large amount of cash, and a list of names of students and how much money they owed her. So not only was she smoking probably, but she was most likely a drug dealer, and so she was facing much more serious consequences. And so her only choice really for her lawyers was to not claim that she was innocent, but to claim that the search of her purse was in fact not justified, and that therefore the exclusionary rule should apply, and that the evidence found against her would not be able to be used. Well, the Supreme Court rejected that claim, and they sort of set a new standard for searches at school. And they said school officials do not need a warrant to search students. Not only do they not need a warrant, as her lawyers were trying to say, but they don't even need probable cause. In fact, they only have to meet a lesser standard called reasonable suspicion. And so that really gives school officials a wide leeway, or a lot of leeway when it comes to doing searches. And the reasoning of the court was that, unlike maybe in public, in schools especially, there's a need for swift discipline and swift action, because school officials and teachers are in charge of keeping students safe at school when they're not in the care of their parents. And you just imagine if a student was suspected of having a gun at school, you wouldn't want to wait. The court's reasoning would be like, you wouldn't want to wait to go have to get a warrant. It might be too late. The student may carry out acts of violence, or if they're selling drugs, someone could be harmed, in that immediate time frame. So that the school would need to respond quickly and not have time to get a warrant. So basically at school, although you have some privacy rights, your privacy rights are very limited. And schools have, again, a great deal of leeway and flexibility when it comes to searching students.
So these next cases deal with the Fifth and Sixth Amendment due process, and we'll deal with those now. That was an odd transition. Anyway, so Gideon v. Wainwright, you can see here, Gideon was an individual living in Florida at the time, and he was accused of having broken and entered into a pool hall and essentially had, stolen some things from there. He was being charged, and he was asking for representation in Florida at the time. The only way a person who was poor could not afford their own lawyer, in other words, an indigent defendant, you should be familiar with that term, indigent means poor, could get a lawyer appointed only if what they were being charged with was a capital offense, meaning that the possible punishment could have been death. And since what Gideon was being charged with was not a capital offense, then he was deemed not entitled to counsel according to the Florida Supreme Court. And what's that?
Free counsel.
Free counsel, right, to the Florida Supreme Court. Anyway, he is subsequently charged and convicted and found guilty, and he then proceeds for the next several years to challenge his petition himself. So here's somebody with very little education who, in fact, educated himself in the jail library and decided to craft or draft his own writ of certiorari, which is the appeal that you must file for this to the Supreme Court in order to have your case heard and reviewed. And the court always loves to pat itself on the back and say, oh yeah, see, we're accessible to the common person. Well, yeah, this was literally the only, I think, if I recall correctly, the only case they've taken from somebody who's written their own writ of certiorari. So, I mean, while that's true, it's exceptionally rare. And so it's not the usual at all. It's not the rule. But ultimately, the question posed to the court was that whether or not the Sixth Amendment right to an attorney, does that apply to state trials? And the court said, absolutely it does. In other words, having a lawyer is fundamental to a fair trial, and the state must provide lawyers to indigent poor defendants. I think it was Justice Black who said it's obvious how important the right to counsel is to justice, or frankly in the legal process or proceedings. You only need to look at how the government itself makes sure to have lawyers in order to prosecute its cases, as well as wealthy people or people who can afford it. Almost all of them are going to make certain that they have a lawyer present to help them prosecute or defend them in the court of law. So if it's good enough for us and necessary for us, And if it's good enough for people who have means and necessary for them, it also stands to reason that it is necessary for someone who can afford one to have one to receive adequate defense and or, if you will, counsel during a legal proceeding. So this, along with some other cases that we're going to talk about here in a moment, are going to lead to something called your Miranda rights. So we'll talk about that at the tail end, but let me put one other, or rather add one other note here. You'll notice that the state has to provide lawyers to indigent defendants. Well, these individuals are called public defenders, okay? Every state has to have them, right? Because this this Sixth Amendment protection has been incorporated through Gideon v. Wainwright to all the states. But what that means, the public defender offices, they exist. So it is true, right? There's definitely counsel now made available to indigent defendants, but the quality of counsel has been brought into question through subsequent court cases. While it's true that a poor person is getting a public defender, what you may or may not know is that these public defender offices are often woefully underfunded and under-resourced, meaning they often are overworked, have too many cases per lawyer, and so they're not able to oftentimes give as adequate defense as they need to. And that's not necessarily an indictment of public defenders themselves. They're well-meaning individuals. They're just under-resourced and understaffed and overworked. And so this really stacks the deck still against a lot of indigent defendants, because while they may have a lawyer, their lawyer is not able to marshal the resources or the time to mount a sufficient defense. And therefore, there have been challenges, and some of them successful, saying, while counsel has been provided, the counsel that has been provided has not been adequate to mount a sufficient defense, and therefore the states have been asked to properly fund or increase their funding for public defenders offices. But as you can imagine, this is a fight that has to be had, and a lot of public defender offices are still very underfunded and understaffed. And that, as you can imagine, poor criminal defendants are not the most politically powerful group. So you can see where there may not be as much of an incentive to adequately fund these offices, because these people don't necessarily come out and vote in the ways that make it dangerous not to listen to them.
Okay, the next case is Escobedo versus Illinois. This is another case that dealt with sort of Fifth and Sixth Amendment issues. Danny Escobedo was arrested for an accusation of murder. He was taken to the police station for a question. This was not his first run-in with the law, nor was it his last. So he had a lawyer, I think, who had helped him out before. And this lawyer showed up at the prison once he found out Escobedo had been arrested, and he was asking to see his client, and Escobedo was also asking to see his attorney. The police refused to let him see his attorney and continued to question him, and he eventually confessed to the murder and ended up being convicted in trial. And his lawyer subsequently challenged the conviction, saying that his rights were violated. And remember, this is part of due process, that you must be guaranteed all of your rights and freedoms, regardless of who you are, regardless of how guilty you may seem or what type of crimes you may or may not have committed in the past. It doesn't matter. Everyone has the same legal rights in every single case and every single accusation of crime. And so, although Escobedo was a person of maybe questionable character, because he got into a lot of trouble after this as well, but nevertheless, he has rights as a person living in the United States. And so, the court, his lawyer said that he should have the right to remain silent, but the court actually decided this on the fact that it was actually a violation of his Sixth Amendment rights. His right to an attorney had been denied to him. But really, if you think about it, both amendments were violated, because he was forced to sort of testify and was not told that he had the right to remain silent, but he was also denied his access to his attorney, who could have advised him not to answer certain questions and so forth. So this case says you must be afforded a lawyer at all stages of the criminal process.
And as promised, we were going to get to Miranda v. Arizona, and you're going to see the court help out law enforcement because there have been, up to this point, a slew of cases now making certain rights fundamental. So in this particular case, the court actually goes the extra step to try and summarize what are the rights afforded to a defendant that's in custody. So what are your Fourth Amendment due process rights? In the particular case before us, the facts are that Miranda had been arrested for kidnapping and rape. And the police subsequently obtained a signed confession after 2 hours of interrogation. Now, I want to give you this information as well. Miranda had, I think it was like a 5th grade education, but no more so than that. And so he was not very well educated. This matters because you'll see that the court focuses in on the fact that, defendants who are not well versed in, their rights or find it difficult to navigate social situations or whatever it may be, that should not be an impediment to them being able to receive a full and robust defense. This is something, again, the stakes are too high with respect to depriving someone of their life. In the case if they're going to kill you if you don't do, or rather if you are found guilty, like in capital cases, or depriving you of your liberty, right? In the 20 to 30 year prison sentence, that's a steep sentence. So that there should be a substantial burden that is met of proof before you can deprive someone of their right to life or liberty. And so in this case, the court said that the prosecution couldn't use Miranda's confession. Now, this case is a little different from Escobedo. If you remember in Escobedo actually asked for a lawyer and then was denied it. In this case, Miranda had not asked, and then subsequently proffered a confession. And the court said that's irrelevant, that in fact there is a proactive responsibility or duty or obligation on behalf of the police to inform a possible defendant, or I should say a possible suspect, of their rights. And so in this case, you have the Miranda rights will come from this case. So you have the right to an attorney, right? You have the right to remain silent. You have the right to be told that anything you say can and will be used against you in a court of law. Obviously, if you can't afford an attorney, one will be appointed to you. So all of these things are rather part of what police must say to you before they ultimately, in the process of arresting you. If they're in fact arresting you, they have to inform you of your rights. And if they don't, then you get into issues with a violation of your due process rights. And again, at that point, it means that evidence that is obtained during that process could possibly be excluded. And there could be other issues as well.
But yeah, Miranda was given a second trial, and without the confession used against him, and he was still found guilty the second time around. So some people think you just get to walk free. That's not always the case, but his rights were violated, so he did receive another trial. All right, so the Eighth Amendment, I believe we're only going to look at one Eighth Amendment case here, although, obviously there are many, but remember the Eighth Amendment, one of the big focuses is cruel and unusual punishment, and in addition to excessive bail and excessive fines. So this case, like many Eighth Amendment cases, deals with sort of the rights of people convicted of a crime, and at what point are they subjected possibly to cruel and unusual punishment. And of course, again, capital punishment or the death penalty often comes into play with the Eighth Amendment. Are those two things compatible? So William Furman, this was, as you can see, was a case in Georgia. I always found this story sort of interesting, or I don't know, it seems a bit strange, but he was burglarizing a home, and the owner of the home apparently confronted him, and he claimed as he was attempting to flee, his gun went off accidentally and shot and killed the homeowner. So he was convicted of murder and sentenced to death. His lawyers appealed this, saying that the death penalty was cruel and unusual punishment, and the court actually agreed, but maybe not for the reason you might think. The court ruled that in this case and two other cases that were decided with it, that the problem with the way the death penalty was being carried out in Georgia and elsewhere was that it was too inconsistent. That, for instance, one person might commit a murder in a burglary, and another person commits a murder in a burglary in a similar fashion, but yet one would be sentenced to be executed, the other might be sentenced to just a lifetime prison sentence or some other type of prison sentence. And so they felt like that it was just sort of arbitrary and capricious, that when the death penalty was being issued to people and when it wasn't. And so the court said because of the randomness of the executions, it was cruel and unusual punishment. But it kind of left the door open for states to rewrite their death penalty laws to make them more consistent and to give juries more guidance into when they should recommend the death penalty. And so, but basically what this case did was it made the death penalty unconstitutional, and death penalties were put on hold for several years. And so from 1972, when this ruling was issued, up until 1976, the death penalty was sort of in limbo and was not allowed to be used in the United States. But in a later case, Georgia rewrote their laws and other states rewrote their laws. And in a case called Gregg versus Georgia, the defendant again challenged a death sentence that had been issued in his case. And in this case, the Supreme Court upheld the death penalty, so it was sort of restored as constitutional. Now, some justices felt like it should always be unconstitutional regardless. So that's a debate we continue to have today. But as of today, the death penalty is still constitutional in the United States. But certain forms or sentences of death have been ruled unconstitutional. For example, executing someone when they commit a crime as a minor has been deemed to be cruel and unusual punishment. Executing someone perhaps who might be found to be mentally incompetent could be considered cruel and unusual, things like that. So there are limitations on the death penalty, but it is, as of now, is legal, and it's up to each state whether they want to have the death penalty as an option, and the federal government as well.
So now we're turning our attention to civil rights cases. The cases we've just looked at all involved a clause in the 14th Amendment called the Due Process Clause, otherwise the processes you are due or owed before the government can detain you or process you in the system. These subsequent cases, or the cases that are going to follow after this slide, all deal with the civil rights clause here, in particular the Equal Protection Clause, and we're going to examine that right now. So civil rights, ultimately what civil rights are, is the right for all the citizens, to be treated equally under the law. So the government's supposed to create equal opportunities and treatment for all people. And if we're looking at the 14th Amendment, when we get there, I'll show you the clause that's going to be instrumental in arguing these cases. It's called the Equal Protection Clause, because ultimately that's what you're asking for, is to be treated equally as other similarly situated individuals in society. So for example, you have the right to be free from employment discrimination based on your race, gender, religion, national origin, etc. Now, one of the complications here is that the way in which the Supreme Court interprets equal protection can be narrow or broad, depending on the makeup of the court. In the case of Plessy versus Ferguson, we have a very conservative sort of Supreme Court, and they're going to interpret equality in a very narrow and tortuous way, I would argue. In other words, that they really torture the real meaning of the 14th Amendment. Why? Well, they ultimately uphold what are called Jim Crow laws. Essentially, these were laws that allowed for states and localities to establish separate facilities for white and non-white individuals. So you could have white white train cars and non-white train cars. And in fact, Plessy versus Ferguson involved precisely that, a situation where an individual wanted to be in the white train car and was denied access because they were found to have, I think it was like or like 1/8 of their blood was, non-white or something to that effect. And it's some students always ask, well, how would they know if like you're 7/8 not, or white or something to that effect? Well, when you develop an entire system based on race and a lot of benefits and privileges come your way because of it, you make it your business to know things like that, as horrible as it is. Now, from this, we're going to get the two types of segregation are going to emanate, right? We have de jure segregation. De jure means segregation enforced by the law, and we're going to have de facto segregation, segregation in fact or in practice without being officially established. Now, we're going to see that the court up to this point today is going to deal in large part with de jure segregation, but there's still a long way to go when we talk about de facto segregation. So remember, I told you that in the 14th Amendment, the clause that is applicable here is going to be the Equal Protection Clause, because in this particular phrasing, you'll notice that it's saying that no state may deny to any person within their jurisdiction the equal protection of the laws. So if a state is imposing discriminatory laws or practices, then a citizen from that state who's suffering from that practice or law may sue under the 14th Amendment Equal Protection Clause.
Okay, so this is a case you guys probably are familiar with, but Brown versus Board of Education of Topeka, Kansas. Kansas, maybe not this first state you might think of as being a state with segregation back then, but in fact, they had an option in their state for each district to decide whether their schools would be segregated or integrated. And in Topeka, the schools were segregated. So in this case, Linda Brown and her family were denied admission to an all-white elementary school that was close to their home. And she was instead forced to travel to a school, I believe walk to her school, which was much further away to the school for children of color or African American children. And so her father said she should be allowed to go to the school closest to her home. And of course she was denied. And the school board in Topeka said, well, we are fulfilling the requirements of, in fact, Plessy versus Ferguson, because they claimed that the school for the children of color was just as good or just as well funded as the school for white children. Now that's disputable, and in fact, we know for a fact that most schools at that time that were segregated by race were clearly not equal. They were clearly in violation of even if you go by the standard of separate but equal. But the interesting thing about this case is it really isn't decided on the idea of whether whether the equal part even matters. It's decided on the separate part, and I'll explain in a second what I mean. But so the question is, does segregation of public education based on race violate the Equal Protection Clause of the 14th Amendment? And the Supreme Court rules yes, and it's a unanimous decision. They say that you cannot have segregation in schools and that it's inherently unequal. In fact, so what they're saying is it doesn't matter if it's equal, even if schools were, in fact, which they usually weren't, but if schools were equal in funding and equal in quality, it would still be unconstitutional because of the fact that they're separated by race. And that essentially by separating people by race, it's having a detrimental effect on the ability of minority children to learn, that they feel like they're the ones being singled out, they're the ones being told they're inferior. And they use some psychological testing and research that back that up. And so although people get confused sometimes about this case, thinking that it ended de jure segregation altogether, that's not the case. This only makes it illegal in schools because of the unique area of education that it's affecting and how important that is. Not that segregation elsewhere wasn't important, but the court, in this case, limited this ruling to schools. It wasn't until later, about 10 years later, with the Civil Rights Act, where they actually banned segregation in all public facilities, such as restaurants, hotels, buses, etc. And so just keep that in mind. So it's a very impactful ruling, but for one, it didn't affect all segregation at the time. And in fact, even with schools, it was largely ignored by many states in the South, especially. They resisted this for many years beyond this ruling.
So as is made clear from this case and others, you're going to see that the courts certainly are charged with making decisions consistent with the Constitution and the laws and what is quote unquote right, but they're also working within a larger context, which is political realities. The courts depend on the executive branch and the legislative branch to honor their decisions and carry them out. In the case of the executive branch, to carry out their decisions. So you're going to find that their courts may limit their decisions at times for political reasons, knowing that if they go too far, they may end up losing any support for their decisions. So this is an example of that to some extent. All right, now we're going to turn our attention to affirmative action cases or affirmative action cases. In this case, I want to first define what is affirmative action. So affirmative action programs, we started first seeing the language around the time of the early 1960s with John F. Kennedy, and then subsequently in legislation that was passed in the 1960s and with Lyndon Baines Johnson, where there were efforts to try and make whole or compensate for the historical discrimination suffered by people of color because of the law. I mean, the racist policies all throughout the country that disadvantaged people of color. And in order to put them on an equal playing field, there had to be some added supports because they were denied a lot of this support, the support, say, white students got or white people received as a result of having laws that benefited them. So the affirmative action programs were meant to compensate for the historical disadvantages that people of color encountered through the law and, frankly, through societal practices. So in this case, though, we have Alan Bakke, who's a 35-year-old white man who wants to gain admission into the University of California Medical School, and he had tried a couple times and had been denied admission, and he decides to focus his frustration on the fact that there was a policy where they reserved 16 places in each of the entering class of 100 for qualified minorities. In other words, minorities that had otherwise qualified for admission based on basic standards and requirements that they had for their program. And Bakke's contention is that his qualifications exceeded those of all of the minority students admitted in 2 years, and the 2 years that Bakke's applications were rejected. And he's saying that this is a violation of his equal protection under the law, 14th Amendment, basically arguing a version of, reverse discrimination. And the court actually, in a very divided opinion, said that actually agreed with Bakke in terms of the strict racial quota. In other words, the court did say that reserving a certain number of spots for students of color was in fact a violation, or indeed, quote unquote, reverse discrimination. And I say quote unquote because there's a lot of dispute and debate around whether or not a person who is in a position, in a system that otherwise advantages them can be experiencing discrimination in the sense of what we mean, right, with the same way that a person who's a minority could experience discrimination. And the argument is that that's not really the same thing. If you are in a system that otherwise advantages you, but you happen to not be able to get into a spot because, you otherwise didn't exceed the qualifications of the other candidates who were similarly situated as you, then that there's another group that is being, looked at because of the fact that they had been historically disadvantaged, right? It's not an apples to apples comparison, and so it's a bit misleading. Nonetheless, the court says you can't set aside these quotas for school admission, but the court did say that diversity is a compelling interest so that having diversity in a college environment is a valid and compelling interest, and therefore the goal for any university nowadays, after multiple other court cases on this issue, was that race can be considered as a factor among many other factors in deciding whether or not to admit a student into your student body or into your school. And this is where we are today. And, obviously there's a lot of debate around how this should take shape, or, what is this still relevant today, and so on. But the takeaway here is that schools can still consider race as a factor among many factors, but they can't set aside quotas or give extra points for the fact that someone is a person of color. They can just consider it as a factor among many.
Okay, so Obergefell versus Hodges, you have to what extent does the Equal Protection Clause apply to people seeking to marry someone of the same gender? So in this case, you had same-sex couples in several states suing their states for discrimination because they were being denied the right to marry based on the fact that they were from the same gender, and those states had laws that made made it illegal or did not extend that right to same-sex couples. And so they challenged this based on the 14th Amendment, Equal Protection Clause, and the Due Process Clause. And so the Supreme Court ends up ruling that, in fact, yes, the Due Process and Equal Protection Clauses of the 14th Amendment guarantee people the right to marry who they choose as a fundamental liberty. And so although this traditionally was a right of the power of the states to decide marriage laws, there's a caveat here to say that states cannot deny someone's right. Remember, the Constitution is supreme, and if the Constitution says everyone has equal protection of the law, equal rights under the law, that those rights cannot be denied on a sort of a random or arbitrary basis. And so this essentially overturns all state laws, or negates all state laws that banned marriage between couples of the same gender, and that applied as well to Georgia at the time. And so this was a big step forward in the area of LGBTQ rights, and that's still an area that's sort of being defined in our society in terms of rights, but this was a big step towards protection for people in that community.
On that note, one of the most recent cases, incidentally, I think this past year, in fact, was on employment discrimination. So now the court has ruled that you can't discriminate based on sexual orientation in the area of employment, which was also a new area, if you will, of protection here for members of the LGBTQ community. All right, so now we're going to look at the right to privacy. To begin with, if you were to look in the Constitution, there's no explicit right to privacy. So I want to just preface my comments on Roe v. Wade by saying that there was a prior case called Griswold v. Connecticut, where the court recognized that that an individual enjoys a general right to privacy when you look at the language of the first, third, I think it's the first, third, fourth, fifth, and Ninth Amendments. I think that's the combination. They said if you look at the first, third, fourth, fifth, and Ninth Amendments in combination, it's clear that the Constitution affords individuals a right to privacy. Even though it's not explicitly written, it's definitely implied and understood, if you will. Nonetheless, Roe v. Wade is going to depend on this notion of a right to privacy, and you'll see here in a moment why. In this particular case, we have Jane Roe, which was a pseudonym to protect Norma McCorvey's identity, and I can say her name now because she herself has come out to identify herself. But anyway, she sought an abortion in Texas where it was illegal unless the mother's life was in danger. And she argued that the state inserting itself into this decision was a violation of her right to privacy, essentially, that the Constitution should protect a woman's right to terminate her pregnancy by abortion because that's her choice, and her doctor make that choice in consultation with their doctor. Obviously, a woman will make that choice. And so that the state really has no business or role here, and this is a violation of her right to privacy. And the court ultimately agrees with Norma McCorvey, saying that a woman's right to an abortion fell within the right to privacy protected by the 14th Amendment Due Process Clause. And the decision ultimately gave women the total autonomy over pregnancy during the first trimester. Let me tell you what that means. That means during the first 3 months of pregnancy, a woman can make the decision to terminate their pregnancy without any governmental interference, or with very little, I should say, little to no governmental interference. But as you probably already know, the gestational period for the human species is 9 months. So the first 3 months, we know that the woman enjoys the majority of the rights, or if you will, redound in their favor in terms of making the choice as to whether or not to terminate the pregnancy. Pardon, guys, it's getting a little later today. Anyway, but the second and then third trimester, you start to see that the state's interest starts to become more and more important or compelling in terms of preserving the life of that unborn child, right, or that fetus, however you want to phrase it, depending on your perspective. The point of the matter is that we see nowadays the court, as it got more conservative, started to allow for more limitations on this right to an abortion. They still held up this ruling, Roe v. Wade, but they've allowed for further narrowing of the kinds of decisions women can make. In other words, they've allowed states to put a lot more limitations and restrictions and conditions on it. And so the most current iteration, or the most current standard, is that you have to allow for an abortion, but states can put restrictions in place as long as they do not create an undue burden on a woman's right to pursue an abortion. And again, that's something for the courts to litigate. And you may very well know a lot of this is coming up as far as debate right now. We have a lot of states that are passing heartbeat laws, or there's also in the current situation, we have a Supreme Court position that's about to be filled, and a lot of people are talking about, will Roe v. Wade be overturned, and what are the implications for women's health? So a lot of the ramifications of this case are still being litigated today and are still fresh in the court of public opinion and debate in terms of where things will settle.